Well, then let's go ahead. Good afternoon. This is the House Judiciary Committee. It is the 30th of January, 2025. We've got 4 whole bills, starting with an administration bill, House Bill 246. We're going to hear that one, I think, but since, are you ready? Come on up. And there will be 2 other witnesses, I think, or 1 other witness, Paul Ellington. All right, fine. No one else. Go right ahead, please.
It wasn't on before. Can you guys hear me now? All right. I'll start over. Take 2. Good afternoon, Chair Clippinger and members of the committee. My name is Carnitra White, and I serve as the Principal Deputy Secretary for the Department of Human Services. We respectfully urge a favorable report for House Bill 246. We're driven by the 12 Moore Miller administration values and believe that this bill exemplifies those values. House Bill 246 prioritized moving with urgency to ensure all relevant records of abuse, neglect, or exploitation of adults we serve through the Adult Protective Services Office can be seamlessly shared with fellow governmental entities conducting investigations. APS serves adults 18 or older who lack the physical or mental capacity to provide for their daily needs. We are charged with preventing or remedying abuse, neglect, self-neglect, or exploitation of adults who are unable to protect their own interests. Our Adult Protection Program provides professional services to protect health, safety, and welfare of the adults that we serve. HB 246 will increase protections against maltreatment and assist in prosecuting abusers. The bill enables faster and more coordination between federal, state, and local governmental entities during the course of a governmental investigation into adult maltreatment. Coordinating governmental entities include the U.S. Department of Justice, U.S. Postal Inspector, the state agencies like the Chief Medical Examiner, the Office of Healthcare Quality, and the Securities Commissioner. Under current law, sharing information with other governmental agencies can only occur by obtaining a court order, which increases unnecessary delays in the investigation resolution and the help for our victims. HB 246 streamlines record sharing so that investigations can be completed faster and with greater urgency. With that, I finish my testimony and request a favorable report and welcome any questions.
Vice Chair.
Thank you, Mr. Chair, and thank you for your testimony. Thank you for being here. I am looking at the, for the definition of health practitioner. Can you speak to that just a little bit? We're not including emergency medical dispatcher because they don't actually render any services other than dispatch services. Is that why? So this bill really is so that we can share information right now if there's a court order. So if there's another investigation with one of the governmental entities that I mentioned that they're investigating and then we can't share information unless they do a court order, this helps us to share that information. That entity would not be one of the ones. Well, if we're listing all state agencies, so if they needed the information, if they have an investigation, we would be able to share information with them. You would not? We would be. You would? If there's, oh, can I ask my Sure. I guess what I'm getting at is if you have, you know, there's a 911 call or, I guess that doesn't. Under this bill, yes, we would be able to share information. You would, okay. Yes. Okay, because in the fiscal note, it says health practitioner does not include an emergency medical dispatcher as defined under the education article. So that's what I was trying to understand.
This brings CPS and APS into alignment with reporters.
I'm okay if the person sitting to your left wouldn't mind answering that question too.
You can introduce yourself.
Like, just identify yourself for the record and go ahead.
Hello, I'm Greg Sesek, Director of the Office of Adult Services. This bill does add health practitioner, bringing in alignment the reporters consistent in CPS into APS.
Okay, you gave me a bunch of initials that I'm not sure I understand
So
everything you said.
it brings into alignment our Child Protective Services and our Adult Protective Services. So they both would now be included in both, for both Child Protective Services as well as Adult Protective Services.
Okay, so I'm going to go to the code that I'm talking about. I'm talking about Maryland Education Code, Section 13516. And there it speaks to, hopefully the definition, yes, it's the definition of an emergency medical dispatcher, which is an individual who has completed emergency medical dispatcher course by EMS, competence in medical protocols, been examined by the board. I was just trying to understand why that group of people, we wouldn't want to share their information. And if you don't have that, if you want to get back to us, you can do that as well.
Maybe.
Yes, thank you.
Thank
Thanks.
Seeing no other questions, we thank you very much. That concludes the testimony on House Bill 246. We'll go now to Delegate Boyce, who just walked in, and House Bill 243. And Jennifer Fairfax, Rachel Bennett, David Bennett, Barbara Bennett. If you're here, that'll fill up the table pretty quickly. Also have Kelly Ray. Oh, it's right there. I'm sorry. I beg your pardon. We've got everybody then. Of all those people that I just called out, I don't know if everybody's up there, but we'll be fine. Delegate, go ahead.
Thank you so much. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. For the record, I am Delegate Regina T. Boyce, presenting HB 243, Family Law Adoption of an Adult. This bill was, for historical references, was also introduced in 2024, in 2023, and I want to take the opportunity to thank you for moving it out of the committee those 2 years. HB 243 aims to reform the adult adoption process by streamlining the procedural steps. The legislation establishes that certain legal requirements, such as the issuance and service of a show order on a prospective adoptee's parents, do not apply if the adoptee is an adult. It grants the court the authority to order investigations before ruling on adoption petitions involving adult adoptees, but only when there is good cause shown. Furthermore, the bill establishes that the parental consent is not required for adult adoptions. Adult adoption happens for a myriad of reasons. In cases of one of my constituents, the adopting parent met the general parameters to adopt her son under the adoption laws for those under 18, including abandonment, abuse, and lack of financial support. However, given the adoptee's age, the process required a host of unnecessary steps for someone considered by law to be an adult. In the context of adoptions involving minors, showcase orders may be issued to notify the legal guardians, including known biological parents, when applicable, granting them the opportunity to object to the adoption. HB 243 eliminates provisions requiring the issuance and service of a showcase order for adult adoptions. The bill operates on the premise that adults, being capable decision makers, have the right to autonomy in managing their own circumstances. Instead of showcase orders, this bill would grant the court the authority to order investigations only when there is good cause shown before ruling on adoption petitions involving adult adoptees. This provides flexibility while ensuring essential information is gathered. The bill addresses various reasons for adult adoption, including inheritance considerations, fostering relationships with adults, accessing crucial medical information, or facilitating reunification with birth families. By doing so, HB 243 aims to strengthen Maryland's family units while minimizing unnecessary barriers in the adult adoption process. Again, I thank you for your time and your consideration of HB 243, and I ask for your favorable report. Go ahead, please.
Good afternoon. My name is Kelly Ray. Mr. Chair, Vice Chair, members of the committee, thank you for having me today. I'm here to share my story for the third time. I came to Delegate Boyce 3 years ago to change the adult adoption laws. I'm hoping the idiom 3 times the charm prevails this year. Thank you for getting it over to the Senate last year. We will work with them this year to get it out of committee. Changing the law to remove parental consent is the right thing to do and will bring Maryland in line with most other states. My son and I did not talk seriously about adoption until he was about 26 because we were waiting for him to become a U.S. citizen. The other reason for the delay was he did not want his birth mother to know his plans. And he was right. She had no need, no right, and had not earned the privilege to know his business. The entire process took an emotional toll on my son. He had moved on from that part of his life, but our laws made him revisit the past. I adopted my son on November 29th, 2022. He was 27. The judge finalized the adoption via Zoom in less than 10 minutes, yet it took us 5 months and a few $1,000s to get to that day. Our journey included hiring a lawyer who understood adult adoptions, serving the birth mother who beat him and kicked him out of the house at the age of 14, advertising in a foreign country as part of the adoption search for the father, having my doctor verify I was in good health and current with my immunizations, completing a home study, and criminal background check. Because my son's birth certificate had no father listed, we had to go over to a foreign country to do the advertising. Luckily, in my network, personal network, I actually had a contact. Adult adoptees should have the right to decide without birth parent notification. We must eliminate unnecessary obstacles for both adoptees and adoptive parents. For many adult adoptees, involving individuals who never provided for them or abused them is unjust. I'm asking you to return a favorable report on House Bill 243. Thank you.
Mr. Chairman, Madam Vice Chair, members of the Judiciary Committee, my name is Rachel Claremont. I was Rachel Bennett when I signed up for this, but have since become Rachel Claremont. And I am testifying again in favor of House Bill number 243. For the first 22 years of my life, I was subjected to verbal abuse and emotional manipulation from my biological mother. Because of these years of abuse, I formed an eating disorder, I used alcohol as a coping mechanism, and I considered suicide. I've spent the last 8 years in counseling trying to make peace with my biological mother's abuse, to learn healthy tools to live with the effects from the abuse, and to grow a new appreciation for my stepmom, who stepped into the role of mom when I was 8. For any abuse victim, a major part of their recovery is taking back their control. For me, that was asking my stepmom to adopt me to ensure that my abuser no longer had her parental rights to make major life decisions for me on my behalf. You can imagine the punch to my gut when I learned I couldn't do this without my abuser's permission. Let that sink in. I spent 8 years in counseling to recover from 22 years of abuse, and now the last piece of the puzzle to my recovery is in the hands of my abuser. Now let me be abundantly clear. The decision to call another person mom and make it official by law is not made lightly. It's a devastating reminder that the person who was supposed to love me unconditionally was the same person who chipped away at my psyche and made me believe I wasn't worth a dime on this earth. So I sit here today, now as a 30-year-old, asking you to take that piece of the puzzle out of her hands and put it back in mine. Put it back in my hands so that I can fully heal from that abusive chapter of my life. Put it back in my hands so that I never need to worry if my abuser will ever have any say over my future children's life decisions, should anything happen, God forbid, to my husband and myself. Take that control that parental abusers have over their victims and give it back to the victims so they can have a shot at a fulfilled life with full autonomy. Thank you.
Ladies and gentlemen, thank you for your time, and I'm thankful to be here and have the ability to speak with you on this important issue. My name is David Bennett. Rachel Bennett Rachel Claremont now is the youngest of my 2 daughters. I want to thank you for your work last year on this bill and your continued work on it. In 1996, my daughter's birth mother and I separated, and the court awarded that I was physical custodian of both of them at the time, ages 2 and 7. During our 2-year separation, while waiting for final divorce proceedings, their birth mother was absent in their lives. She neglected to show up and visit them at the prearranged court-ordered times. I got to a point where I wouldn't even let my daughters know when they were supposed to be visiting with her because I didn't want to cause them stress and disappointment. At the final divorce 2 years later, I was again awarded physical custody by the court. That remained in effect until they were adults and the order expired. My daughters continued to live with us until they moved out on their own. Other than the testimony today and the testimony last year, I have never publicly spoken about the mental abuse the birth mother has caused my 2 daughters. Their birth mother has mental issues and everything revolves around her. It is rare for her to take responsibility for her actions or inactions. Many times she made my daughters feel guilty and that it was their fault. Once my daughters were in their teens, their time they spent with their birth mother was further reduced at both of their requests. The environment was not healthy. Their well-being, their schoolwork, their social activities were never a priority. This left my daughters with feeling of guilt at times, and it almost came to tragic emotional problems through their young lives. Neither one of them have had any contact with their birth mother, one for a year and Rachel for many years. Thankfully, my wife Barbara, here with us today, sitting next to me, came into their lives 23 years ago. She chose to become their mother to my daughters and was perfect for them, giving them the emotionally and motherly love and guidance that any great mother would do. She still fulfills that role today. Just a year ago, she was with my oldest when she gave birth to one of our grandchildren. Rachel made the decision a few years ago as an adult in her late 20s that she would like Barb to adopt her. But we found out that the law does not allow that without the consent of the mother. The court saw fit on 2 separate occasions to award custody of the daughters to me and not their birth mother. When a person reaches the age of being a responsible adult, they should be allowed to make the decision legally of who their parents are. Rachel, my 30-year-old adult daughter, college graduate, successful in her profession, married, homeowner, and all-around great person, is not able to make that sole decision on who's legally her mother. Instead, the law currently written allows the abusive parent to still have that last bit of control over an otherwise successful, well-adjusted adult. I appreciate your time. Thank you.
Mr. Chairman, Madam Vice Chair, members of the committee. My name is Barbara Bennett, and I am Rachel's mother. Let me first thank you all for the hard work and support from last year for anonymously voting in favor of passing this bill. You've heard from Rachel and her reasons for working so hard on getting this bill passed, and you've now heard details from her dad on why the adoption process should not be in control of Rachel's biological mother. What you're going to hear from me is what I consider to be a more logical approach as to why this law needs to be changed. Meaning of an adult. I actually looked that up to see what was written because we all think we know what an adult is. And it came across the meaning of responsible for where you are going, what you are going to do the rest of your life, and most importantly, being responsible enough to make decisions. The next thing I looked up was the meaning of emancipation. I know, bear with me, you will see where this is going. Emancipation is defined as the fact or process of being set free from legal, social, or political restrictions. It's a liberation, which is defined as providing a release from a situation which limits freedom of thought or behavior. Minors go to court to be emancipated from a parent. Why? So that the court can decide if it is in the minor's best interest. But if a minor reaches the age of 18, gets married as a minor, or enters the military under the age of 18, they do not need to go to court. Why? Because they are now considered an adult. So why does Maryland have a law that, to me, appears to contradict the true meaning of being an adult? Supporting this bill does not affect anyone but the adult who wants to be adopted. It allows them control over their own assets, control of their well-being of their family, and control of the well-being of themselves. Supporting this bill doesn't help someone's political career. It doesn't cause the voters to have to pay additional taxes. And let's be honest, how often does an adult child want to be adopted? If a biological parent were the parents they are expected to be, then this would not happen. So I ask you, why would you not pass this bill? I read that one of the defined responsibilities of an adult is self-care and emotional maturity. Emotional maturity is defined as taking responsibilities for your feelings and your actions. Isn't this what Rachel's trying to do today? Tying everything together that I just said, isn't Rachel trying to take responsibility for her feelings and actions and promoting her own self-care, which, as a reminder, is a responsibility of being an adult, by emancipating herself from her biological mother, meaning she is freeing herself from legal and social restrictions, as well as liberating herself from her biological mother? I am confident that this committee will unanimously vote again in favor of passing this bill, and I look forward to testifying at the next level. Looking at the time, which I guess I'm out of, I was going to give you a quick story that I personally experienced with her mother, but I'm going to save that for the next level. But being designated officially as Rachel's mother through the adoption process allows me, as her mother, the peace of mind that my child is no longer suffering. Isn't that something we all want with our children, a peace of mind? Thank you.
Thank you.
Now we'll hear from Judge Fairfax, please.
Hi, thank you so much, Chair, Vice Chair, members of the Judiciary Committee. I wish I could be there in person. My doctor didn't allow for that today. I did come and testify in person last year as a member of the Judiciary. The Judiciary does support House Bill 243 with regards to adult adoptions. I want to share that before I came to the bench, I was 20 years as an adoption attorney. And over those 20 years, I handled a lot of adult adoptions. The other thing that I think is important to share is that I was licensed in multiple jurisdictions, the District of Columbia and Virginia. And I share that because my experience in private practice is that in the District of Columbia and in the Commonwealth of Virginia, adult adoptions do not need the consent of their parents in order to complete an adult adoption. Maryland was an anomaly in this regard. And the result to Marylanders was that they would pay thousands of dollars more to complete an adult adoption in the state of Maryland, if that's where they lived, and if they lived in one of the neighboring jurisdictions. The other thing that I want to share is of the hundreds of adult adoptions that I did, they were often stories like Rachel's, where it was a step-parent situation. There are also adult adoptions where children have aged out of foster care, and their foster parents want to adopt them. And those young adults have to then find and serve the parents whom they were removed from by the state because of allegations of abuse or neglect or findings of abuse or neglect. And they then have to also serve those parents and get their consent to proceed. And so this really places young adults similar to Rachel in a very difficult situation of being re-traumatized later in their lives when they decide to take the very important step of securing the parental rights of the person whom they have a bond with and who they view as their parent. And I think that this bill would help save a lot of trauma for a lot of Marylanders. Thank you.
All right. Are there any questions? Good to Delegate Valentine, then Cardin.
Thank you, Mr. Chairman, and thank you, panel, and thank you, Delegate, again for bringing this bill. Two quick questions. One was already touched on. Delegate, can you confirm that last year's vote in the committee and House were both unanimous votes?
Yes, Delegate.
And the second part is this bill in the exact same posture as last year's?
Yes, with some slight changes from the Judiciary that just clarifies the bill. So in essence, yes.
Thank you.
Thank you so much.
Thank you, Mr. Chair. My questions were both answered. I just wanted to thank you guys for coming in and testifying on this difficult issue. We see Kelly all the time, but you guys, thank you very much for coming in.
Thank you. Are there further questions for this panel? Seeing none, thank you very much. That concludes the testimony on House Bill 243. I believe, yes, okay. Delegate Acevedo now, please, for House Bill 165. Do you have anyone with you? Ken Phelps, Zainab Chaudhry, virtually Aubrey Edwards-Luce. Delegate, go ahead for 3 minutes.
Thank you, Mr. Chair, members of the Judiciary Committee. This bill is a reintroduction that essentially ensures that we're protecting children, that we are ensuring that their rights when in police custody are preserved, and we are essentially seeking to balance accountability with the rights of a child. I will also acknowledge that we have done a good job over the years in passing laws that protect the rights of children during interactions with law enforcement. We passed the Child Interrogation Act that ensures that kids parents are notified whenever their kids are in custody, and that a child has available the counsel of an attorney. But what we did not take into the consideration is the fact that it is still legal for law enforcement to lie to children, which is fundamentally wrong. When we're talking about a child, we're talking about a developing mind. We're talking about people who are susceptible to the kind of tactics that adults would not, for whether it's reasons of development or experience. And what we essentially want to do is to protect all of our kids. And this bill that creates a rebuttal presumption for children who, in police custody, may or may not have been lied to during an interrogation, that there is a rebuttal presumption, and that child's words aren't used against them in a juvenile or criminal proceeding. I'd just like to point out some really important facts, one being that the majority of false convictions, in the United States are the result of false confessions. And false confessions, as we know, as we've seen in cases such as the Central Park now exonerated 5, these false confessions, when elicited, could not just put the child or children in a situation where their life can be changed, in cases of criminal proceedings for the worse. And this is fundamentally something that changes the trajectory of a child, their life, as we saw with the case of the now exonerated 5. And so this bill is essentially ensuring that we finish the work of the Child Interrogation Act, which protects children. Again, this bill is about protection. Law enforcement should not be lying to children. Law enforcement should not be using deceptive tactics on children. And I am convinced that there is no one in this room, in this building, or really in Annapolis, who would feel comfortable knowing that their child, their nephew, their niece, that neighborhood kid that you saw growing up, being in custody of law enforcement, and knowing that they can lie to them, and whatever they say, as impressionable as young people are, would then be used against them. This is a remedy to that, and my hope is that this committee will continue the work of the Child Interrogation Act by passing it, and I urge a favorable report. Thank you.
I'd like to go next, please.
That's fine. Delegate Clippinger, Delegate Bartlett, members of the committee. I'm Ken Phelps, the Episcopal Diocese of Maryland, also co-director of the Maryland Episcopal Public Policy Network. I'll refer you to our written testimony, which was written by my co-director, who is a recovering lawyer, the Reverend Linda Boyd, my smarter, better half. Basically, we just need to do better when it comes to our children. I will not be the first one to remind you that budgets are moral documents, that where we invest our resources and how we shape our policies speaks volumes about how we value members of our society. And we are a culture that worships violence and death and revels in punishment, believing that mass incarceration is the answer to many of our societal woes. You've heard arguments supporting this bill. You've heard and read statistics that cry out for the more difficult path to reconciliation and restoration if we only have the courage and wherewithal to pursue it. Though the term war on drugs has fallen into disuse, the pattern of mass arrest continues and seems to be expanding. These are our children, and the solution to meeting their needs and the challenges they face is not to increase the numbers that are introduced into the criminal justice system. In all circumstances, the Church pleads with you. They deserve dignity and respect and investments of resources that are an expression, a loving expression of that respect, as opposed to the impulses of our innate punitive natures. We need to do better, whether it is adopting this bill, adopting restorative practices in schools. We need to break this practice instead of simply rebranding it. The Church requests a favorable report. Thank you.
Ms. Edwards-Luce, please, on virtually for 2 minutes, please.
Thank you so much. Good afternoon, Chairperson Clippinger, Chairperson, Vice Chairperson Bartlett, and members of the House Judiciary Committee. My name is Aubrey Edwards-Luce. I live in Prince George's County, and I'm the Executive Director of the Sarah Neil Meyerhoff Center for Family, Children, and the Courts at the University of Baltimore School of Law. CFCC submitted joint written testimony in support of HB 165 with our sister center, the Center for Criminal Justice Reform. CFCC and CCJR strongly support HB 165 because lying is one interrogation tactic that is known to lead children and adults to make false statements. And due to their brain development and immaturity, when youth are lied to, they can produce false confessions at a rate that is 2 to 3 times that of adults. In one study, approximately 36% of people who made false confessions and were later exonerated by DNA evidence were minors. The harm of false confessions extends well beyond youth who are wrongfully convicted. False confessions and wrongful convictions threaten law enforcement's ability to hold true perpetrators of crime accountable and prevent those same perpetrators who have been from being adjudicated or punished. The case of the Central Park Five, now known as the Exonerated Five, illustrates this problem, and you can read more about that in our written testimony. While no child should have to worry about being deceived by law enforcement, the current policy makes the stakes of false confession and wrongful conviction even higher for youth of color. When police lie to children, prosecutors should have the burden to prove whether the child's statement was voluntary and admissible. HB 165 is a crucial step toward protecting youth's due process rights and achieving true equity. For these reasons, CFCC and CCJR strongly support HB 165 and urge a favorable report. I'm happy to take any questions.
Vice Chair.
Thank you, Mr. Chair. I just have a question for, I'm not sure who can answer this, but does Utah have such a bill? Such a law, I'm sorry.
Delegate, yes, Utah does, along with 2 other states, Illinois and I believe Oregon are 3 states that have passed similar laws to this, ending the practice and legality of law enforcement lying to kids or using deceptive tactics, yes.
Mm-hmm. And does Delaware have such a law?
I know there's been some bills introduced in Delaware. I'm not certain whether it's passed, but I know that there are efforts in other states to introduce and pass similar legislation to this.
Thank you.
Delegate Valentine.
Thank you, Mr. Chair. I did have one question. If you could, thank you, Delegate, and thank you, panel. Very curious about this topic in general. Did you have the opportunity to read the testimony of the State's Attorney's Office Association? I just wanted to speak to this because I was actually thinking the same thing with regards to the legislation that's been passed already. And I'll directly quote the comment that stated, have you read that?
I saw their statement from last year.
Okay, I don't know if it's the same statement, so I just want to see if it is, and correct me if I'm wrong. With the past legislation prohibiting investigators from speaking without the consultation of an attorney, and nearly every jurisdiction with juveniles not speaking with attorney or with investigators, is this in fact a solution that's in search of a problem?
I don't agree with that characterization. I think in addition to the Child Interrogation Act that provides some protection, certainly not all that we could provide, but that provides some protections to children in terms of notifying the parent, access to counsel, the time in between that, and even during when a child is in custody, it is very likely for a law enforcement officer to make a statement or to say something to that child, that wouldn't be true, and the child being impressionable or believing it could make a statement that could wrongfully implicate them in something that they didn't do. So while there are protections under the Child Interrogation Act, as I said in my testimony, it doesn't go far enough. We do have to do all that we can to ensure that law enforcement does not use this tool, specifically lying or deception to kids.
In any kind of contact, not just the custodial interrogation? Is that what I'm?
Yes.
In any type of contact, any type of, like, say, transport or any type of thing?
Correct.
Okay. I just wanted to clarify. Thank you. Thank you, Mr.
Thank you all very much for coming in and testifying. To the gentleman on, I guess, your left, our right, thank you for your testimony. want to ask you about some relativism, maybe moral relativism or ethical relativism in terms of if a police officer is using some sort of deceptive practices, would it be okay for a juvenile to lie to the police officer in return? If one's lying to one, can the other one lie back? This is not really a legal question. This is more up your alley.
Well, I think, I think the problem here, the issue is, it's the system we've invested in. So, I think either, takes us down, the wrong path. Our knee-jerk reaction is gotcha. It's to be punitive. It's to punish. And I don't have the statistics, on hand to talk about, how we may, actually, it may cost us less, right, to go down a different path, which offers a restorative path, rather than, the supporting of a system which continually, adds to the prison population and gives us, the current situation we have. I think it's more of a systemic question.
Thank you. Thank you. Delegate Acevedo.
Can I intervene? I'm sorry, I made a mistake. Ms. Chaudhry has not been able to speak yet and was going to testify on the bill, and I apologize for that.
I'm actually her coordinator.
First time in several years this has ever happened. Apologize. We're going to give her time to speak, and then I'll go back to you, Delegate Cardin, and we'll go from there. So I do apologize very much. Go ahead.
Thank you, no worries. Good afternoon, Chairman and members of the Judiciary Committee. My name is Kimberly Suardi. I'm actually Ms. Zainab Chaudhry's outreach coordinator. And on behalf of the Maryland Office of the Council on American Islamic Relations, I thank you for this opportunity to testify in strong support of House Bill 165. House Bill 165 establishes a rebuttal presumption that statements made by minors during custodial interrogations are involuntary and inadmissible in court when law enforcement intentionally uses false information to elicit them. HB 165 is a critical step toward ensuring fair treatment and due process for Maryland's children, particularly Black and brown youth who are disproportionately targeted by law enforcement. The use of deceptive interrogation tactics on minors has been well documented to result in false confessions leading to wrongful convictions and lifelong harm. According to the Innocence Project, nearly 1/3 of wrongful convictions overturned by DNA evidence involved false confessions, with minors making up a disproportionate share of these cases. Deceptive tactics such as lying about evidence, falsely promising leniency, or misrepresenting legal rights explore a minor's trust and lack of experience with the criminal justice system. HB 165 is particularly relevant to Maryland's diverse communities who are more likely to experience racial profiling, school-to-prison pipeline policies, and police misconduct. CARE urges Maryland to join states like Illinois and Oregon, which have passed similar protections against police tactics targeting minors. HB 165 does not prohibit police from conducting interrogations, but ensures that any statement obtained through deception is subject to higher scrutiny before being used in court. We respectfully urge you vote favorably on HB 165 to safeguard children's rights, prevent wrongful convictions, and hold law enforcement accountable for unethical interrogation practices. Maryland's youth deserve a justice system that is fair, transparent, and grounded in integrity. Thank you for your time and consideration. And
Thank you very much. Thank you, Mr. Chair, and thank you for that eloquent testimony as well. Delegate Acevedo, it's not often that we agree on something. That's wonderful that we may actually be able to work together on this.
I'm going to call the local station.
The custodial interrogation has to be videotaped, according to the testimony of the chiefs of police and the sheriffs. Is it possible that there could be some sort of deceptive practice that could happen in advance, even if it's not in an interrogation, in advance of that custodial interrogation?
Absolutely. Just the example I provided earlier about, let's say if a child is stopped and interrogated by police, they would notify the parent, they could notify counsel, but in between that time, there's a lot of time where, a child could have spoken to an attorney and afterwards could have had an interaction with law enforcement where that law enforcement officer wasn't forthcoming, told a lie, et cetera. So there's quite a bit of opportunities for something like that to occur, and that's what we're trying to avoid.
Right. In fact, couldn't it be possible that a police officer from, say, Baltimore County gets a call about some youth, some children that were misbehaving, and goes and investigates and finds children that he believes or she believes might be the ones that they are going to try and investigate, separates them before a custodial interrogation, before they're being brought into the police station. There could be some interactions that could be manipulated deceptively to try and engage them in thinking about how they're going to react during that custodial interrogation, even before they are technically arrested or brought into the station. Is it possible that could happen?
Absolutely, and there's Supreme Court precedent, if I recall, where there have been instances, Frazier versus Cup case, but it's very, very likely, yes, Delegate, based on what you described.
So if they're not permitted to use deceptive practices, or if they are permitted to use deceptive practices, that could influence the conversation that happens with the attorney, and then the conversation that happens, afterwards with the police officers in some sort of interrogation. It's possible that could happen.
Very possible,
Okay.
yes.
Thank you.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to the witness on the far end. You said that your remarks are the position of the church, is that correct?
Yes, sir. For the Diocese of Maryland, yes.
The what?
The Diocese of Maryland, the Episcopal Diocese.
Episcopal?
Yes.
Is that correct? Okay. Thank you very much.
You're welcome.
Seeing no other questions now, thank you very much. Apologies for the mistakes before. And we'll go now to those in opposition. We're going to, I think it's Scott Schellenberger, and virtually, Chaz Ball. Okay, put them on. Mr. Schellenberger for 2 minutes.
Mr. Chairman, thank you very much. I don't believe we need House Bill 165. It was just a couple of years ago that the state codified what was originally Senate Bill 53. And I'll tell you a little bit about 53 in a second. But please remember, when we're talking about custodial interrogations, for decades, since the 1960s, the rule of law in this entire country was Miranda. If you gave somebody your Miranda rights, your right to remain silent, you can say anything. If you gave somebody your Miranda rights and they waived those rights, that applied to adults and to juveniles, okay? So Miranda rules for 50, 60, 70 years. And then 2 years ago, when Senate Bill 53 came along, this body decided, Miranda's not good enough for us now. And so what we're going to do is we're going to codify Courts and Judicial Proceedings 3-8A 14. When they arrest a juvenile and they want to talk to them, they have to notify the parent or guardian, which I can tell you in real life is hard to always find. They must tell the parent or guardian the child's location, tell them the reason they're in custody, instruct the parent on how they can find the children. But the most important thing is they may not conduct a custodial interrogation until the child has consulted with an attorney. Now, that never applied before. People could always waive. But the important thing here is the public defender's office in this state has honestly put a public defender on call 24/7. And so I can tell you in the vast majority of cases, when they call that public defender, they say, don't talk. And because of that, we're really not talking to many juveniles, even though Miranda's been complied with. And more importantly, one example, apologize, 1 second. One example, if you have 4 teens who are involved in a carjacking and you have evidence against the one and you want to know who the other 3 are, and the PD says, don't talk, well, then that person's going to take the blame for the crime all by themselves, even if the parents wanted the person to talk.
Thank you very much. Thank you. We'll go to Mr. Ball now, please.
Good afternoon, Chair, members of the committee. My name is Chaz Ball. I represent the Maryland Fraternal Order of Police, and I'm asking for an unfavorable report. The law of the land, the law of this state, is that a statement must be voluntary. So these custodial interrogations must be voluntarily given. A judge would review it and make a determination whether it's voluntary, and a jury would be faced with the same question as to whether the statement was voluntary. And if the statement is not voluntarily given, then a judge would not consider it, nor would a jury. The rights that were given under SEPA are expansive, but this specific bill seeks to unreasonably and unnecessarily restrict the abilities of law enforcement in this state when it comes to juveniles. The fact is, most individuals, when they commit a crime, they don't just go in and say, I've committed the crime. Typically, officers have to do interrogations and talk to individuals in order to get information. One of the tools in an officer's tool bag in order to get that information, while still being on the constitutional side and making sure that that statement is voluntary, is the ability to utilize subterfuge. Subterfuge has been upheld by Maryland's Supreme Court as well as the United States Supreme Court. Subterfuge, such as saying, your buddy, he's in the other room, and he's saying that you're the one with the gun. Or, I found your fingerprints on the weapon. Subterfuge such as, there's a video that shows you doing it, might lead to individuals confessing and make our state more safe because we can create those types of cases. It's a tool that's in the box. If an officer goes beyond that, takes it to a point that it's no longer a voluntary statement, then the statement would not be able to be utilized. But being deceptive or using subterfuge or using the ability to try to get someone to believe there's other evidence that isn't there in order to get a solid confession does not violate and should not violate our law.
Questions, Vice Chair?
Thank you, Mr. Chair, and thank you, Chaz. I'm sorry, I can't remember your last name at the moment, but Ball. That's what I was thinking it, but I wasn't sure. Thank you, Mr. Ball. So you might have done something that I tend to do, and that is forget the full rule. And the rule is not just voluntarily. There's more to that, right?
Yes.
Okay, so let's talk about the other 2 things that are required. What are the other 2 things that are required?
Well, if they're in custody.
I'm speaking to Chaz. I'm sorry.
Oh, I'm sorry.
That's okay. That's okay, Mr.
He'll know better.
Freely and knowingly?
Excuse me?
Freely and knowingly?
Right, so knowingly and intelligently, right?
Yes.
Yeah, so that intelligent goes to what you believe to be true. So the whole premise behind this bill, do you agree, is that the child is going to believe something to be true that may be false? And so therefore, could it be said that their confession or anything that they say is not done voluntarily, knowingly, and intelligently?
No, they know ultimately the truth as to whether they committed the crime. Now, if they didn't commit the crime and they're told you're on video doing the crime, then that they would say, well, that it must be somebody else. But if the use of that subterfuge to get them to say, oh, there's evidence there, they're going to catch me, leads them to make those types of confessions.
So even if it's false evidence, it doesn't matter?
If the evidence isn't there, but the reality is this law would allow either the juvenile or the attorney for the juvenile to come in and say, is there a video? Are there prints? Or is anybody made any statements? And the officer would either have to say no or say, I can't answer that question, which would mean there's a no.
I'm not sure I understand what you're saying. Let me just make sure I understand. Are you saying that in the instance where a law officer could say, we have a video of you committing an X crime, when they don't in fact have that video, and therefore someone confesses to a crime, are you saying that it's okay for them to confess because they did in fact commit the crime?
Yes, I mean, that's the purpose of the subterfuge. But I'm saying this bill specifically, I could go into a statement for a juvenile as his attorney or her attorney and say, officer, do you have a video? Officer, is there any fingerprints? Officer, is there any DNA? Officer, what's the name of the witness?
I understand that. So you're saying that that officer cannot lie to the attorney?
That officer can't lie to the attorney or the juvenile. If this bill were to be passed, then a defense attorney or a juvenile would have the ability to force the state to reveal its entire case.
Imagine that. Okay, thank you.
For your very eloquent testimony. But I'm going to focus with Mr. Schellenberger for a second. Thank you for coming in, State's Attorney Schellenberger. So the reason I brought up that example, I have been unsupportive of this legislation in the past, although it has been, for me, it's very tough to say that it's okay to lie to kids. When there are big signs all over my college campus that says, it's not nice to lie to cops. Big signs, but it's okay to lie to kids. I had a case where 4 kids, a family called in that their son got beat up. These are like 11, 12, and 13-year-old kids. They were on the look for 4 kids. They found them playing basketball. The alleged victim was sitting there watching. They took all 4 kids, they separated them, put them onto curbs, didn't interrogate, the kids were allegedly able to leave if they wanted to. The parents were in their screen doors during the summer, were able to just knock on the doors and tell the parents, didn't, took the kids downtown before alerting the parents, which I don't think is allowed, and then separated them, starting doing a custodial interrogation. But during that period they were on the curbs, the kids were getting a lot of information that was deceptive in practice, suggesting, and by the way, everything was null prost in the end. This happened to have been in Baltimore County. Unfortunately, it happened, whatever. But when I start to think about the delegates' bill, and I'm thinking, maybe we shouldn't allow police to do this. Just follow the rules that we have that we're supposed to be doing of investigating and doing it all without deception and lying, and we don't have this situation. I'm just going to put that out there.
So you have to remember that the example that you gave the delegate, that interaction with this juveniles would have been recorded on body camera. And if there was something...
It was all recorded on body camera.
Agreed. And therefore, if they are read Miranda, the waiver must be knowingly and voluntarily made. So I have to prove that before I can ever try to use your statement in the courtroom. And Maryland law now would require those police officers in the case that you gave me would require at the moment for them to call the public defender and say, can I talk to these kids? And I can tell you in the vast majority of cases since the other bill passed, the public defender is telling everyone no. And I'm not criticizing the public defender. They're doing their job as they decide to do. All I'm saying is we don't need 165 because we already have sufficient guardrails in place with the one we passed 2 years ago.
And I'll just end with, for that period of about 45 minutes before they were in a custodial interrogation, there was not necessarily interviewing, but there was communication happening, whether it be without words or insinuations, potentially very deceptive, that got these kids ready to do whatever they could to get themselves out of trouble. And that concerns me greatly.
And you would be able to litigate the motion that the admissibility of the later confession should not come in because it was not knowingly and voluntarily done because they had been deceived before they had even read Miranda.
And after 6 months, it was all no pros. So they decided that it wasn't worth proceeding. But so then you question the time and money spent on all of this because of that. I'm not putting it out there, but thank you. I appreciate it. This is a tough one. This is a tough one for me.
Thank you, panel, for coming in to testify. I just want to be on the same page, and I hope that the general public can be on the same page. What is the meaning of subterfuge? Can anybody help me out on that?
So subterfuge would be an example that two people have done a carjacking and they're juveniles. They've been arrested and they comply with the law by reading Miranda, consulting with the parents, and the public defender this time says, go ahead and talk. Subterfuge would be a detective in one room saying, you better tell me what happened. After everything, all the legal requirements have been waived. Subterfuge may be, you better tell me what happened. Your buddy's next door spilling the beans.
And could you go further and say, and if you tell me what happens, I can guarantee you'll get less time?
No.
You can't say that?
No, you can't make any promises.
That's not a part of subterfuge, which means trickery, evasion, deceit, deception. I'm looking at the meaning.
I understand, but I would say that the judge would not allow that.
So you're telling me that an adult is supposed to teach their child that officer friendly is now going to be officer tricky, deceitful, and full of deception, right? And if you are guilty of that, could you or should you be personal liable for that?
Well, there's a lot of questions here.
Okay.
Again, it has to be a knowing and voluntary statement. And therefore, if there is deception, it could go to the heart of whether it was voluntary or not. And nowadays, Maryland law requires that the public defender be consulted. And so if the public defender says go ahead, that still wouldn't stop them from litigating whether something that happened in that room was illegal or not. And I certainly would defer to Mr. Ball if he has any additions.
I'd say the same thing. Going beyond the, I can control what type of sentence you get. That goes beyond the pale. But however, saying something like your buddy is in the other room and he's talking, or as I stated, there's the witness described someone that looks exactly like you and said your name or something like that. It could lead an individual to confess. I mean, that's ultimately what this the entire idea of custodial investigation is, either to get the individual to confess or to get the individual to trap themselves in a statement where they no longer have credibility.
Okay, and in that case, could a juvenile, by confessing, have their parents be held accountable for either their correct confession or false correct confession? Is that possible?
I don't believe
we're looking at holding parents accountable for juvenile activity.
But that bill requires it to be held accountable for the crime, not necessarily for the fact that the juvenile confessed.
Yeah, well, so if they held accountable for the crime that they falsely confessed to, and then you prosecute the parents under a false confession, then what recourse do the parents have?
Again, they would still be able to litigate their involvement, but you may have noticed that I was not testifying in that bill. I did not involve myself in that one.
Thank you very much.
I have a couple, but if that's okay, Mr. Chair, since I haven't asked anything all day. I didn't want you to think I was sick, so, but anyway, my question is for Mr. Ball. Would you agree with me, sir, that most of your members are very talented?
Can you say that question again? I'm sorry.
You're from the FOP, right?
That's correct.
So would you agree with me that most of your members are very talented?
Sure.
And would you agree with me that an officer can obtain a conviction of a juvenile without lying? Has that ever happened before and different things like that? Where somebody's been truthful, but
without using subterfuge, sure.
Yeah.
And I'd say that it's a tool in the bag, and where this bill would restrict one of those tools.
Well, if you're able to get confessions, you just said in response to my question that your members are talented and that they've been able to get confessions without lying. So my final question is, you've just said they can get convictions or confessions without lying, and your members are talented, so why do they have to lie in the first place?
It's a tool in their bag, the use of subterfuge in order to get an individual to make a confession. There's convictions without DNA, but DNA is very helpful. There's convictions without fingerprints, but fingerprints can be very helpful. There's convictions without video, but video can be very helpful. A tool in the bag of law enforcement is the ability to get the individual who committed the crime to confess to the crime.
Right. And just one more for Mr. Schellenberger, if I can. Mr. Schellenberger, they've already articulated for us, the proponents, that Utah has a similar statute and that I think it is Illinois also. So, but you've been around a while. So in those states where this practice, what Delegate Acevedo wants to do, is already in practice, have we seen a spike in crime in those states? Because, you know, Mr. Ball, and I respect his view, is saying, well, we need to be able to do it. But where, if in places where they're not allowed to do it anymore, have we seen a spike in crime?
I am not sure the answer to that, but I think the fact that it's limited to 2 states means 48 other states have not enacted it. And if we're going to go by numbers, then the bills I testified about yesterday in the Senate, where the vast majority of states do have something and we don't, I hope that you would help support that also. But just 2 states, I don't think shows that there's this national need or national trend to add this additional thing to, as Mr. Ball says, take one tool out of the toolbox.
Thank you, Mr. Chair.
Vice Chair.
Thank you, Mr. Chair. So this question is for, this time, it is for Mr. Schellenberger. So is it a crime to lie to a police officer?
Yes.
And is there such a thing as persuasive or coercive entrapment? You know where I'm going with this.
Sure.
Okay, so when someone commits a false confession, as we know children often do, is there entrapment?
I don't think so. I think that we have to look at the entire investigation and make sure that we have more. And I think our folks do that. And as Delegate Cardin, who walked away, pointed out, obviously somebody in my office had a problem with the way that case got dealt with, and they got rid of it. So, you know, that's the thing. I tell my prosecutors all the time, you have one job in life, and that's always to do the right thing. And many times doing the right thing might be to dismiss a case that you're concerned about how certain people behaved. And we do that all the time.
One last question. So Delegate Cardin did bring up the no pros for those situations. Generally, what happens to an individual who is charged with an offense prior to the state's attorney determining not to prosecute? Well, especially for a child, since we're talking about children.
Right.
What could happen along the way?
Well, I mean, theoretically, if the crime were bad enough, they could be held in a juvenile detention facility. But the rules regarding how quickly our office has to move in juvenile cases are way faster than the adult rules. So for instance, we have in adult cases 30 days to make a decision about whether we're going to go forward or not, and in a juvenile case it's 15 days. And so we have to move very quickly. And again, we aren't the people who said they are going to remain in a juvenile facility. A master or a judge has made that decision, depending on what jurisdiction you're in. So, I mean, this is still all being done in front of judges, all being done, and the juveniles classically have representation by the public defender's office or a private attorney. So we're not talking about things that are done behind the scenes.
I'm not sure where you're going with that, but I appreciate the response.
Okay.
Thank you.
Sure. Thank you, Mr. Chair, and thank you, Delegate, for this bill, and thank you to the witnesses that are here today. So just in doing a little bit of research, because this is my second year on this committee, but I did notice that in addition to the states that were mentioned, Illinois and I believe Oregon and Utah and Delaware have now come on board. So I guess first I'd like to say that just because two states may have a law, when we find good legislation, it's generally duplicated, and then that becomes across the nation a good practice or best practice. But with saying all that, I did learn that Nevada and Utah, they have now simplified their Miranda rights for youth. Is that something that you would think is, are you aware, first of all, that it exists? But secondly, would that be an area worth considering? Well, while we're in this subject area of conversation.
I'm not sure when you say to someone you have a right to remain silent, how you can make that easier to understand. You have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. I mean, I would listen to someone tell me that there can be simpler words, but I'm not exactly sure how you can make it much simpler than it is.
So that would be a no?
No, that would be, I'm happy to look at anything somebody puts in front of me.
Okay, okay. Yeah, I think,
But
you know,
the concern I have is that then the simpler words might not convey exactly what was meant in Miranda, and then it could suppress the statement. So I think we have to just be very careful there. Just, you know, if they change the words, then it could make a problem.
And this is just for youth interrogation.
Okay.
Okay, no, I just want to be clear about that. And then my second part, wanted to inquire about, since we have as a state really hone in on this subject area and making sure that the defense attorney is available for the youth, have we seen significant trends of this being an issue with the interrogation that you're aware of since that we've made some changes?
Well, since the vast majority of the time the public defender tells the juvenile not to talk, that means that we're not getting as many co-defendants. And it also means, and this may have something to do with some other bills that were passed, like the odor of marijuana and things like that, but I can tell you the number of guns that have been seized have been dropping. I don't want to specifically blame this one, but it's the combination of a lot of the laws that have been passed in the last couple years. The number of guns that are being confiscated, particularly as a result of car stops, has gone down a lot.
Okay, thank you very much.
Yes.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. Thank you, Mr. Schellenberg. I appreciate you. I just want to know, since anything that a juvenile may say can and will be used against them, when the law enforcement asks them a question like, what's your name? Is it appropriate for them to just be silent? Just look at you like they don't know what you're talking about?
They can be, but typically information like name, address, age typically is not a problem.
It should be, because now you're gathering information, right?
Right, but now you have
anything that is said can and will be used against them, right?
Correct. So now the problem is, what's your name? How old are you? Who are your parents? All right, I'm going to charge you, and we're going to take you to court. And in reality, if he told him his name, his age, and his parents, the kid might have been going home. Even if they got charged, the child might have gone home. I can't tell you how many juvenile cases the condition is that they be released to the custody of their parents. It happens constantly, and that's the way it should happen.
Okay, so you're saying in most of the cases, if the person, juvenile, does not cooperate, you're going to charge them anyway and take them in?
If they have proof there's a crime, because they wouldn't have any other choice. They couldn't call the parents if they don't know who they are.
All right, thank you very much.
All right, that concludes the testimony on this legislation. Thank you very much. It's House Bill 165. We're going to go to the final bill. It's House Bill 120, Delegate Taveras. It's Delegate Taveras and Erica Lemon from Legal Aid. And Lori Ruth is favorable with amendments, but fine, come on up and we can have all three.
Yeah, I'm favorable.
All right? Delegate Taveras for 3 minutes, please.
Thank you. Thank you, Chair Clippinger, Vice Chair Bartlett, and committee members. It's an honor to be before you all. I'm here to ask for your favorable report on HB 120, Family Law, Child Support Capacity of Minors to Initiate Defend Action as amended. This bill grants underage mothers the ability to file for child support without the permission of a parent or guardian. Across the state, young mothers face significant barriers when seeking the financial support of their children, often due to parental consent requirements that delay or prevent timely action. This is not just an issue of legal access. It impacts the well-being of children, the stability of young families, and reaffirms cycles of poverty. We see this in foster care cases. In our state, around 5% of births each year are to teen mothers, many of whom face financial instability. Nearly 30% of children living as single mothers are below the poverty line, and these circumstances are exacerbated when teen mothers cannot access child support due to legal hurdles. For example, in Prince George's County, teen birth rates for those ages 15 to 19 declined by 20%, from 24.7 in 2013 to 19.3 in 2017. However, the rate among Hispanic teens increased 53.9%, making it significantly higher compared to Blacks non-Hispanics, which was at 12.8%, and white non-Hispanic teens, which was at 4.7%. In addition, the teen birth rate statewide for those 15 to 19 of age has disproportionately impacted Hispanic and Black teens. It was 73% just in 2022 and has consistently been in this range for several years. Teen mothers are less likely to complete high school, with only about 50% graduating by age 22, compared to 90% of women who do not have children during adolescence. By allowing young mothers to file independently, this bill addresses a critical need and ensures these families receive the support they deserve. Through this legislation, we seek to provide a practical solution to help young mothers have agency and advocate for themselves and their children. It will empower them to take responsibility for their child's well-being and ensure access to the financial resources necessary for a more stable future. And I'll just close with this, if you'll allow. Yes. Moreover, this bill will reduce the burden on public assistance program by promoting self-sufficiency. So in closing, I ask this esteemed committee for a favorable report on HB 120, supporting our young mothers and their children. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, members of the committee. Thank you for this opportunity to come to you in support of HB 120. This one, yeah. Oh, okay. Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Erica Lamont. I am the Advocacy Director for Children's Rights from Maryland Legal Aid, and we are supporting HB 120 as presented by Delegate Taveras. This bill ensures that there's no question that minor parents can obtain support on behalf of their children. Receiving child support is a right that belongs to the child, and it belongs to the child regardless of the age of their parent. We all know it's well advertised, the impact of poverty on children. It impacts their education, their health, their emotional well-being, their brain development, and so many other areas. And so being able to establish support and financial support on behalf of your child is extremely important. This bill directly relates and would benefit our clients. So we represent children throughout the state who have been abused and or neglected by their parents. Our minor parents, even though they might be in the custody of the Department of Social Services, their children may not be. Their children, they could still have custody of their children and be responsible for caring and caring for the needs of their children. And so they should be able to seek support, the financial support that their children deserve. We must eliminate any unnecessary barriers or delays to them being able to petition for the support of their children. Whether or not their child receives support should not be in the hands of their abusers or the people that neglected them. For those reasons, Maryland Legal Aid requests a favorable report for HB 120.
Good afternoon, Mr. Chair, Madam Vice Chair. My name is Laurie Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence, which supports this bill, but we didn't actually put any testimony in. I am here to testify sort of on my personal capacity as a member of the Maryland State Bar Association Family Law Section Council. And I know you all see Michelle Smith regularly. She was in court today, so I was available. We also support this bill and urge a favorable report, although the Family Law Section does have a few what we consider extremely friendly amendments, and I think that Ms. Smith has been speaking with the delegate about that, and you'll see that in our written testimony. The fiscal note is very clear that the law in Maryland neither says you can or you can't file for child support if you are a minor parent, and we think this very simple bill would make it clear that they can. Minors are allowed to they're considered to have lack of capacity, or a disability is sort of the legal term, except in certain areas, like in the Health General article, minor parents are allowed to make health decisions about their minor children. It gets a little confusing linguistically. And so this bill is another thing that would allow a minor who is a parent to file for child support. And we think it's important for the reasons already stated. Not everybody has a guardian or an adult that cares for them, that is willing to go and file, that is willing to support them. And this would allow the person who needs the child support to seek it. I just want to say that we had considered, the section had considered other amendments. For example, we considered talking to the delegate about adding custody to this. And if anybody remembers when Delegate Atterbury had about, I don't know, 5 years ago, the bill about outlawing marriage for people under 18, there was also discussion of the fact that minors are not able to divorce. So we left that. I just want you to think about it. And Mr. Chair, if I give just one quick example. If I am 16 and I go to the Office of Child Support Enforcement to file for child custody against my child's 18-year-old father, he may, and people often do, immediately go to circuit court and file for custody. And if I'm 16 addition, I don't have the capacity without going out and finding a next friend or a guardian to file a countersuit for custody. And that freezes the child support case. And so that's why the section was considering custody as part of this. And I just offer that to you as mostly information. I don't want to upend this bill at all. Thank you.
Thank you very much, Mr. Chair. Thank you for bringing the bill as well, Delegate. I guess I wonder about what you brought up, which is regarding capacity. You know, I don't know procedurally how you file a petition for child support, but I'm thinking of capacity. I'm thinking of minors not being able to actually contract, right? And is a petition sort of a contract? I mean, do you have to file it under terms of perjury, et cetera, et cetera? I just wanted to kind of visit with that a little bit, and if there are any other barriers procedurally to filing a petition that a child or minor might also encounter.
I'll defer to I think we have one more person to testify, but I'll defer to the lawyers on the technical question.
Absolutely.
Yeah, there's already a provision in the rules that permits this, but it's not clear that it's in the statute, so that's why we're requesting it. So no, there wouldn't be any concerns regarding capacity.
And just to add, I think if this body passed the law, the child support agency would take those cases. I mean, that's how this works. So I'm not terribly concerned about that either.
Okay. Thank you.
Thank you, Chairman. And buenas tardes, Delegate. Thanks for bringing this bill
Buenas
forward.
tardes.
For an adult to launch this process of child support is very complex and intimidating. Can you give me a scenario of how a minor is to go about getting in touch with the attorney and the process and procedure? What organizations and institutions are in place that they can come in contact with? Because this is a very tough process to go into. What resources are available to them that, one, educate them and then get them into the system? How would this work?
There's basically Maryland Legal Aid.
Okay, thank you.
Community Legal Services. A lot of those bodies are available in your committee testimony right now on your laptop, that they have filed and submitted letters of support. And there are, once this legislation starts to pass, there's Clínica del Pueblo, Mary Center and such, there are entities within the community that can speak to how to assist.
Thank you.
Delegate Boucher, there's also the statewide family law hotline that's operated by the Women's Law Center of Maryland that I managed, worked on for 15 or more years. And we give people the telephone number for the Office of Child Support Enforcement and say, for $25, which is waivable if you have poverty, you can file for child support. And then the Office of Child Support Enforcement does the work. And yes, they have to know the name of the other parent and maybe a birth date, you know, some information, but it's information that's given out all the time.
All right. So it's already in place. We just need to shift it for the juveniles. Thank you.
Thank you.
What else? All right. Seeing no further questions, that concludes the testimony for House Bill 120 and concludes the testimony for legislation today. We will be back on Tuesday with bill hearings. And
all right. Thank you so much, everyone.
And thank you very much.
Thank you. No, thank you.